Hello, everybody, and welcome to our discussion of topics and cases in patent law. My name is Joe Murphy.
My name is Reza Mollaaghababa.
And I'm Reza Sadr.
So today we have a really interesting case, and it goes to the heart of a lot of people who are on YouTube and love YouTube like I do. This is whether GoPro is infringing the contour patents. So let's look at the devices we're talking about here. And obviously, when you're looking at from a patent law perspective, you look at the claims, which we'll get to. But here are the two devices we're speaking about. So on the left is the contour handheld point of view camera device, and then I just put up a GoPro Hero 13 there. I think that's the latest one. We're not going to do a side-by-side comparison. We're instead going to look at the claims. To give you a little background on this case, Contour IP Holding is the company that makes the cameras, owns two U.S. patents, 890-954 and 896-694, which relate to these portable point-of-view video cameras used for action sports and to capture scenes from a user's point of view. And so the patents, and they're identical specifications, so we're going to be looking at discussing just the one. But the patents describe the hands-free point-of-view video camera using a wireless technology, Bluetooth, basically to send real-time information to a remote device, which allows the users to view what's being recorded and adjust the recordings remotely. So, of course, now with these cameras, typically they're going to be, I will watch a lot of cycling videos, so it's folks on gravel bikes or mountain bikes. You put the camera on your helmet or on the bars. Sometimes people hold them on the what do you call them, selfie sticks and things like that. And so with these patents cover technology where the video gets sent to your, say, a cell phone on your handlebars or that you're looking at. And that's really what is at the heart of the case. So let's look at the claims real quick. And this is claim 11. Only two claims were asserted. So we've got claim 11 from the 954 patent, and I think it was claim 3 from the other patent. But this is representative. We'll look at it. I cut it down a lot because I understand on the TV it's hard to, or your computer screen or whatever, it's hard to read the whole claim. I can put a link. Actually, maybe I'll put the PDFs or links to the PDFs in the description below to the patents. So claim 11, we've got a portable point of view digital video camera comprising, and then there's a lot of elements, right? We've got a lens, we've got the image sensor, wireless connection protocol device. So that's basically your Bluetooth. And we've got a camera processor configured to, and I think here we get to the heart of the case. Receive the video image data directly or indirectly from the image sensor. And then here's the real key: generate the video image data, a first image data stream and a second image data stream, where the second image data stream is a higher quality than the first image data stream, and cause the wireless connection protocol device, the Bluetooth, to send the first image data stream directly to the personal portable computing device for display. So basically what you've got is the first image data stream is lower resolution, so requires less, so you can send it over Bluetooth easier, requires less bandwidth. The second data stream is going to be higher def, and that's going to be recorded directly to the memory inside the camera itself. But seeing that lower def image stream allows the user to adjust the camera settings or move the camera around and things like that. I'm going to just pop through a couple of diagrams here. Here's from 954. Here's a flow diagram. I'm not going to go through it step by step, but basically you've got the camera, and you've got the BT is a Bluetooth data transfer is permitted. The viewer controller would be, for example, your iPhone or whatever your phone is. And this just shows how the data gets sent back and forth and the controls between them. And again, this is from the 954 diagram patent. I think this 954 patent, I think it's well done. I think it's got a lot of meat to it. Here's a schematic that I put up from one of the figures, and it shows, you know, the recording of the video, couple separate audios, recording on the SD card, and it shows that there's some wireless communication and things like that. So all these are set forth in the specification itself. for the 954 patent. Again, the other patent was identical. So I think that's sort of the background, the technology we're talking about. Now, I think Reza Sadr, you wanted to talk about the law a little bit for us.
Yes, thank you, Joe. Let's go to the next slide, which demonstrates the law in flowchart format, just to show what the law is. In fact, we have two of them. I'm going to go over them. Left-hand side flowchart essentially shows the steps that are given to us and evolved under Alice for subject matter eligibility as applied by the Federal Circuit. As you see, after establishing the interpretation of the claim, there are two steps shown here. Step one is just the text of the Section 101, whether the claim falls into the four categories of eligible subject matter. Almost every claim will pass this, but then the main part of the analysis starts under Alice, which is whether, although it is within those categories, still is it eligible, or does it fall under some of the areas that the Supreme Court has deemed ineligible. So in step 2A, under Alice and Mayo, which is there, it's called step 1, we have whether the claim is directed to one of those exceptions, law of nature, natural phenomenon, or an abstract idea. Natural phenomenon also is often included in it, is the product of nature. And specifically in this case and many other cases, we are dealing with the abstract idea exception. If the answer there is no, then we exit the Alice analysis and we deem the claims as eligible. However, if the answer to that inquiry is yes, it is directed to one of those exceptions, the inquiry doesn't end. We go to step two of Alice, Mayo, or what is here in this flowchart, step 2B, the second part of step 2, which then asks, even though the claims include those exceptions, are directed to those exceptions, the question is whether the claim still recites additional elements that amount to significantly more than the judicial exception. There are all these terms here that need to be interpreted. In step 2A, we have those directed to terminologies, and here we have this significantly more and things like that. We'll see how different results revolve around these terms. Anyways, if this inquiry comes out on the left side, yes, means there is significantly more, then the claim is deemed subject matter eligible. If the answer is no on the right, then it's not, and the claim fails. What we have on the right is essentially the same steps, step 2A part, magnified a bit, and that's actually the interpretation by the Patent Office of the law, which is not inconsistent with what Federal Circuit has said before, only it zooms in further and adds additional kind of criteria to make it easier for the examiners to decide. So in step 2A, it's broken into two prongs itself. Prong one says, does the claim recite an abstract idea or other exceptions? And again, there are definitions or explanations of what recite means. If the answer is no, then the inquiry ends and the claim is eligible. If the answer is yes, we go to prong 2, which is, does the claim recite additional elements that integrate the judicial exception into a practical application? Again, if the answer is yes, the claim is considered eligible. If the answer is no, which then we go, the overall conclusion is that step 2A comes out against the claim so far. The claim is directed to a judicial exception. Then we go to step 2B as it was already explained on the left-hand side. So as I said, this is the patent office detailing the step 2A, what makes it a bit more accurate. Now, if we go to the next slide, please, what we have there is how this law was applied by the lower court. The lower court essentially decided that the claims are ineligible. So it came in favor of GoPro, but in the appeal, the Federal Circuit reversed that, and we're going to get to that later. So for the district court, what we see is that it stopped at Alice step 1. I'm going to show that again, but essentially they characterized the representative claim as directed to an abstract idea, and they said what that abstract idea is. It's creating and transmitting video at 2 different resolutions and adjusting the video's settings remotely. That was the interpretation of the claim or the characterization of the claim by the district court. And they said, okay, so it fails step 1 means you have to go on to step 2 of Alice. And there they concluded that the claim only recites functional result-oriented language with no indication that the physical components are behaving in any way other than their basic generic tasks. All that means under step 2, there is not significantly more, and thus the claim overall fails the Alice/Mayo analysis, and it's ineligible. So that was the next slide shows that they held that the asserted claims were patent ineligible. Okay, now if we go to the next slide, which I've shown the same claim 11 now, in light of the flowchart which we had shown before, as you can see here, those elements in the body of the claim, the camera processor configured to so on and so forth. Essentially, what the district court is saying is that on the right in the flowchart, that means step 2A is directed to one of those judicial exceptions, which is an abstract idea. The answer is yes. So we go to step 2B, and there they decided that there is no elements that amount to significantly more, and thus the answer is no, and the claim fails. This is how we can demonstrate the analysis of the lower court. However, the Federal Circuit had a different opinion about it, which Reza, I think you're going to present that part.
Yes, thank you, Reza. And so Federal Circuit didn't agree actually with the lower court and held that the claims were in fact eligible under the Section 101. And if you go to the CAFC analysis slide, Joe, that would be great. Basically, the idea here is that this point of view camera, they said that that is claimed, basically provides an improvement to the technology. It solves a technological problem. And in particular, the idea of generating in parallel 2 streams of data where one stream is lower resolution and the other one is higher resolution, and using wireless technology to transmit the lower resolution data to a remote device such as a mobile phone, and then using that data to be able then to change various settings of the camera was essentially a technological solution to the idea of to this issue of how to manage the problem of somebody who's using it and they can't really see what's going on, and how, and therefore they won't be able to adjust the settings of the camera. So if you go to slide 12, as a result, the CAFC said that the patent is not directed to ineligible subject matter, And therefore, there is no reason to go to the next step of the 101 analysis. As Reza Sadr mentioned, the first question is it directed to an ineligible subject matter? And if you say it is, then you have to worry about whether there are additional steps that would potentially make it eligible. But here, CAFC said that we don't need to go further because the answer to the first question is that it is not ineligible. It's not an abstract idea. One thing I want to mention about the CFC analysis is that they went through and they said, okay, how do you do this? How do you sort of deal with this step one? And they said that really what you need to do is to determine what the focus of the advance over technology, over prior art is in the claim. And then to sort of take the next step and say whether specific means or methods have been claimed that basically relates to that advancement. So it shouldn't just be a result, but it should include particular structure, means, or methods that achieve those results. And here they relied on this idea of generation of two streams of data in parallel and how it's being used to say that there were specific structures, the specific means were disclosed, and therefore they reached this sort of final conclusion that the claims were in fact eligible under Section 101. So that's sort of the end of my little quick summary of CFC holding, but I think there's a lot of interesting issues that this case brings up that maybe we can discuss in the next few minutes.
Yeah, one thing that jumped out at me, a couple things jumped out at me, but the first thing was I really thought it was interesting how the Court of Appeals said that that they characterized the district court's analysis as being at an impermissibly high level of generality. So really, this thing seems to ride or fall the decision on how you characterize the nature of the invention, I guess. I mean, so the Court of Appeals said the technology the invention allows technology to operate differently than it otherwise could have. Whereas it seemed like the district court looked at the problem too narrowly. And so I think that's interesting. It kind of raises the question to me, is it better to put like almost a problem solution kind of analysis within your spec and say, this is a technological problem we're trying to solve, and this is how we solve it?
Yes, I think exactly to your point, maybe if we step back, this case and very similar cases, there are at least two major points we can derive from them. One is the fact that the law is still very unclear and thus malleable. And we can go over some details how we see that in this case, including what you said, Joe, that looking at the same law, two different courts came up differently, although that's quite common in law. But here, even in details, how they looked at the same details and still could interpret it two different ways that came with two different answers. And for the same reason, I think the second point is because the law is so unclear and malleable, there are some techniques that we as the patent practitioners can learn from this case and similar ones to use them in drafting our applications, both in the detailed description part and in the claims, to increase the chances of the claims to pass this threshold of 101 analysis. And we can go over some of them from this case. I think those are very important for us as the practitioners. And we can start with unclarity of the case or of the law, and then go into the techniques. I can come up with a few. But Reza, maybe you wanted to say about something.
Well,
about
I think going back, that's really good point. Going back to what Joe was saying, actually the district court and also GoPro, they relied heavily on this previous case, U case, where basically the idea there was that you take two images at different exposures and you use one image to enhance the other. And that was deemed ineligible by appellate court. And the reasoning was that, well, I mean, this is a fundamental practice in photography. It's really nothing more than just using what was done. It's just sort of essentially, you know, an abstract idea. You just take, you know, two images and use one to enhance the other. And that's the way they had basically, as you said, Joe, that's the way they had presented the claimed invention, or the focus of the claim invention, as this case talks about. And CFC in this case said, no, in this they distinguished this particular GoPro case by saying, this is more than that. This is not just you know, using wireless technology. This is not just sort of claiming a result, because what they are saying is that they are generating in parallel, and they really focus on this generation in parallel of the two streams of data to say that it provides a technological solution to a technological problem. All of that, okay, but one thing that I was thinking about is the claim doesn't say to generate in parallel, but that was a construction that was basically brought up during inter partes review when it was accepted, and CAFC says that's the way the claim should be interpreted. But let's assume that was not the case. Let's assume it was just generate the data. And what would have happened in that situation? Presumably CAFC would say, well, this captures some prior art ways of doing it, and therefore it's not patent eligible. But that's where I think a very difficult confusion arises in these cases, because no matter how you do it, if it is a technological, if you provide enough means of doing it, it's a technological solution. But here, not only do you need to provide means of doing it, but the means of doing it presumably have to be inventive. Essentially, the inventiveness problem comes into the 101 analysis. And I think it creates a lot of real confusion here in terms of how you treat these types of claims.
Exactly. You see, that's actually one of the areas that I think the law is not well settled. So the way I look at it is like novelty or non-obviousness is crept into 101 analysis. You have to know or actually compare what's in the claim and invention with what is already known. And in fact, the terminology that the Federal Circuit uses is what's the common practice or long-held areas of practice. So, and that's why the whole rigorous approach of 102 or 103 is not needed here. It can be just a judgment by the judge or by the examiner. But now that's one side of the coin, which I mentioned. The other side is how we can, I think we as practitioners can address that and use that, is make sure we make it clear in our detailed description, to some extent, use language which says, this is not long held, and not say that explicitly, but explain it, that this whole thing is not that something that the technology never had before. We are adding these features, and these features solve a technological problem. Again, that's another language that the Federal Circuit uses, that this should be a technological solution to a technological problem. You mentioned that, and that's a language which actually has got into the guidelines for the USP2 as well. So again, explicitly or implicitly in the spec, I think we have to make that clear. What is the problem, the technological problem, and what could be the solution that we are presenting, again, without narrowing our claims. That's one of the lessons, at least.
I think that's a really good point. And I think I'd mentioned earlier that I thought the specification was good, was very good. And there's a point where the Court of Appeals brings that up, and they discuss preemption. So, basically, when a claim abstractly covers results without regard to the specific process or machinery for achieving those results, creates a preemption concerns, because it would prohibit all other persons from making the same thing by any means whatsoever. But the draft of the specification kind of got around that, and the court pointed to this, because it said here, when read as a whole, claim 11 is directed to specific means that improves the relevant technology. The claims require a specific technological means parallel data stream, and mentions the low quality recording wirelessly, and then the high def recording. And the claims do not cover other ways that a camera processor might generate multiple video streams of varying quality for wireless transmissions. As you mentioned, the courts, as you mentioned, Reza, as such as streams created in sequence. So I think looking at the written description, which discloses improving these point of view cameras, this technology through specific means, not just at a high level of generality, but being very specific about it, I think is really important. The fact that, these claims were saved at least on 101 grounds, because of the way the specification was drafted. I think that's something we should all keep in mind.
Yeah, I agree. I mean, one of the things that here they say, as you say, Joe, and Reza mentioned as well, is the idea that you can't just claim the result. You need to provide a specific ways of getting to that result. But I think the flaw in these types of analysis, at least in my humble view, is that, again, going back to generating the streams of data, that by itself is a specific, but they suggest that you need something more than that. Not only should it be specific, but it should also be inventive. And that is where I think it gets really confusing, because yes, even if you go back to the telegraph cases, it's clear that you cannot just, claim a result. You need to have some specific structure of achieving the result. But the preemption that they bring up, in my view, if you have come up with a solution to a problem, and it's inventive, and you provide a specific ways of doing it, you should get a very broad claim. You may be able to preempt the entire universe from practicing it. So that should not necessarily be the end of the story. I mean, it's true that these cases talk about preemption, but on the other hand, that by itself, in my view at least, should not preclude somebody from getting a claim that preempts others, as long as it's inventive and it's enabled and it provides enough structure.
I fully agree. This is another lesson here. You mentioned the Telegram case. You're talking about the very old Morse case, right? Which is considered like grandfather to many of these cases. So Reza, to your point and what Joe said earlier, I want to look at it from a different point of view. You're absolutely right that once you have all those characteristics, at least you should be given the pass for the 101. And if there is any analysis needs to be done about whether this is really inventive or not, that should happen in 102 and 103 part of the analysis, which needs more rigor, which needs evidence, which needs finding prior art, all of which now is bypassed here. Now, and I think, and that's how the others have crept into this 101 thing. But I think one lesson we can learn here, and you did mention it, Reza, is, and actually Joe also said how well this application has been drafted. If you have drafted your application in a way that it doesn't convey its abstract, it's very detailed, it explains the structure, explains how I do it, that already gives them an idea, a feeling that, okay, this doesn't seem to be abstract. This is very tangible. And Joe showed those figures, which eventually doesn't have anything to do with the details of the claim, all those different components of the device, what does what transfers, how are those streams transferred. That in the spec already helps to show this is not abstract. This is a very technological solution. So by that I mean, We have to do that in the spec. In fact, Ferris Strickwood in the analysis several times said, this is how we interpret this, this claim or this term in light of the specification, in light of the details that are in the specification, included the generating, which were two parallel streams, how they're useful. So this is important, how in the spec, we can help our claims to look like they're much more tangible and much more detailed. That's another lesson I think we can learn about drafting a good, well-detailed application. I don't know what you think about that.
No, I agree. I agree with that.
Yeah, that sounds great. Yeah, perfect. So, well, that's a great case. Well, thanks for the discussion, and I'll put up the Morse claim so people can see, because that's an interesting claim. I think it would have preempted the internet basically, so people could take a look at that too. So, well, it's great speaking with you. So, thanks so much.
Thank you, Reza.
Have a great day.
Thank you. Thank you.
Bye-bye.